Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. I keep pointing out just how critically important these motion in limine filings are and how interesting and what a turning point that these hearings and whatever Judge Hippler's rulings are will be. I'm going to give you another example as to how and why, if you could find the time to watch some of these hearings live as they are telecast on the Ada County YouTube channel, that you should. And I'm going to point to the defendant's objection to state's motion in limine regarding alternative perpetrator evidence. Now, just some background. Remember, as we said before, the pleadings in these in limine motions, look for this when Judge Hippler calls them up. Motion, response, reply. So if he calls the motion in limine regarding alternative perpetrator evidence, which is what we're going to talk about right now, this is the state's motion. So you expect to see someone from the state side. If it's Ashley Jennings, if it's Bill Thompson, someone from the state side is going to get up first and address the court because it's their motion. So this is, again, state's motion in limine regarding alternative perpetrator evidence, and I'll give you the opportunity to read it. It's published on the docket in Idaho versus Kohberger, and you can go ahead. I encourage you to read it. There's some legalese at first, but get the bottom of page 2 is where it gets into this case, and it gives the state's reason. It says that Mr. Kohberger needs to comply with the rules of evidence and the State versus Meister case, which is controlling precedent, that Judge Hippler will, if he agrees, we're going to look at that case. That's a case from the Idaho Supreme Court, and what it basically says is that the Idaho rules of evidence 401, 2, and 3 are what controls regarding admissibility of evidence. You might be saying, well, shouldn't all evidence be admissible? No, it shouldn't, because if evidence is irrelevant, if it is junk science, if it doesn't pass muster with regard to being truly evidence that should get in front of the jury because it's not based in fact, it's some sort of wild theory out there without anything to support it, it shouldn't get into the case. But so what the state did is they came forward and they said that Mr. Kohberger should be required to comply with Idaho rules of evidence 401, 402, and 403 regarding any alternative perpetrators that he brings up. In trying to raise reasonable doubt, he may say, not only is it not me, but it's this person over here or these people over there. And I'm going to explain to you why. State wants to make sure that the jury isn't confused with a bunch of junk information that is not grounded in thought and reason. Reasonable doubt means just what it sounds like. It's thought based on reason. So the defense came back and had a few things to say about this motion in their response. Remember, motion, response, reply. So when you hear that it's the state's motion or the defendant's motion, you're going to see the state getting up first if it's their motion. You're going to see the defense getting up first if it's their motion. Then the other side has their chance to address the court in a response. Motion, response, reply. So the defense, let's just say that Judge Hippler has already heard from the state regarding the motion in limine on alternative perpetrator evidence. Well, then he's going to turn to the defense counsel. What do you have to say? Now, why I think this is going to be a really interesting one is because, first and foremost, defense comes back almost to say, look, you don't have to tell us. We understand we have to comply with the rules of evidence. Mr. Kohberger has a right to argue alternative perpetrator under his constitutionally protected Sixth Amendment and other rights, and they go into their legal theories, why this motion should be denied. They asked Judge Hippler flat out deny this motion right away. But the really interesting part, as far as I'm concerned, comes at the bottom of pages 2 and 3. Last paragraph on page 2. The state argues that literally thousands of tips regarding possible perpetrators were received by law enforcement during the course of the investigation, and that none of these tips were substantiated with the exception of information regarding the defendant. That's Mr. Kohberger. Defense says the state is correct that over 45,000 tips have been disclosed, and tips continue to come in daily. Then this next statement. Please note this, bottom page 2, top of page 3. This case is full of alternative perpetrators. And then there's a footnote here citing to a sealed document, unfortunately, because I, for one, would like to get some more information regarding what the defense is talking about here. Next, the state has chosen to focus on Mr. Kohberger at his own peril. Mr. Kohberger will produce offers of proof related to many alternative perpetrators in this case that will meet the Idaho rules of evidence, ladies and gentlemen. Many alternative perpetrators can be connected to this crime. Let's read that again. Many alternative perpetrators can be connected to this crime, according to the defense. Conclusion. The court should deny the state's motion in limine regarding alternative perpetrator evidence. Alternatively, the court should reserve ruling. That means don't rule on it right now. Give us a little bit more time on this motion until Mr. Kohberger provides an offer of proof that can be evaluated under the standard for admissibility set out in State v. Meister, 2009 Idaho Supreme Court case that the state also cited to. Said that that's the legal standard, that's the precedent, which Judge Hippler is very big on precedent. He's a district court. Supreme Court is a higher court than a district court, and he is compelled to comply if there is something, if the Supreme Court of Idaho has said the sky is blue, he's got to go with the sky is blue. He can't go with the sky is white and gray, just by way of making it a very, very simple argument here. That's why these motions and these responses and replies are filled with case citations, rules of evidence, procedural rules. It's because the court has to go with precedent. Otherwise, we'd have all types of wild legal theories and people wouldn't know where they stood. What's the law? What's not the law? So the state came back in their reply and just basically, they did not agree. Go ahead, give them a little bit of time, but there needs to be, it's got to be reasonable. And the state here is being reasonable, I think, because Dyer is just over 3.5 months away, ladies and gentlemen. And if Mr. Kohberger is able to come out with these many, in this case that's filled with alternative perpetrator, state's got to have a little bit of time to investigate. But this is the sort of motion that I think explains why these hearings are so important and why I strongly recommend that you participate. If you're watching this channel, you're obviously interested in the case. So again, the motions in limine will be heard. We're waiting for Judge Hippler's order to come out. I'm predicting it's going to be either tomorrow or Tuesday because the hearings are Wednesday, and he usually comes out either the day before or 2 days before, and we'll set out a schedule, what's closed, if there's any closed hearings, what's open, and then if he wants them in a certain order, as he did with the motions to strike the DP back in November, he'll list them. But in any event, remember, when you hear him calling the motion, whosever motion it is, they're going to get up first. The response, the opposing party then gets up, and then there's the reply. Let's not forget about the reply, because that's the filings that you see on the docket, and that is the originating party. Whoever filed the motion is going to get up and have the last word, replying to the response. They don't get to argue their entire motion all over again. This is going to be just a reply to the response. If you have any questions, comments, please leave them here. This is Kathy. Thank you very much for joining us here today.